What's up, court nerds? Let me get served. I wasn't gonna make this clip, but my man Derek Smith, if you've a court nerd, you have been following this guy. He's been changing deals, throwing out Bernstein, wanting a new another defense attorney, all this stuff going on, and Judge Conlon has had enough. Today was sentencing. To judge the impact statement and everything else. So what I did was I'm going to cut the clip. I'm going to give you part 1 so you guys can watch it because it's not on the internet anymore. And then I will edit part 2 for you and you will be coming up shortly. So without further ado, here he comes, withdrawing his plea at the final hour. This has just happened. Let's roll, nerds.
Carrying the point of Mr. Henderson, that's here.
Your Honor, Marshall Craig on behalf of Mr. Derek Smith.
Mr. Smith, can you hear us?
Yeah.
All right. Today's date and time set for 2 things. One is your attorney has filed a motion for what is called a Ginther hearing for ineffective assistance of counsel. I'm going to start with that. And then we are going to.
I already know you're going to deny that, so you can just get past that if you want to, because you biased. So go ahead and deny that. Get to what you got. Go ahead, go.
Okay, Ms. Kracher, I've had a chance to review your motion, and I've had a chance to review the people's response. I'm happy to hear any highlights from you if you wish. So what would you like to inform me of?
Sure, Your Honor. Again, I understand the court has reviewed the motions and the response. I'm just going to highlight a couple of things briefly, Your Honor. First of all, I will start with the response from the people. The people represented that defense counsel negotiated a resolution to 11.5 years to 25 years. My client indicates that that was actually the first offer brought to him by Mr. Feaster. Moreover, the issue that my client wants to bring up is that he continuously made requests of defense counsel regarding evidence. We've already had discussions about the ladle. We've also had discussions about the 2 knives. I believe the ladle is very, very important to this case from the aspect that it would have been able to allow defense counsel to impeach the complaining witness at that time, about her testimony. Also, when defense counsel and my client met, there was numerous conversations. My client explained that he insistently told defense counsel that he was innocent of this crime. And defense counsel, knowing that, continued on this path of not investigating the case. Specifically, there is no motion made to have any analysis done on the 2 knives that were located at the scene. I have one couple of other points to make. Ryan, give me just a moment, please. And also, it was going to other comments made by defense counsel relative to the coerciveness of, you're going to be convicted at trial. You are not going to be able to jury is not going to be able to get over the pictures. All of this is ineffective in coercing this defendant to make his plea. So I believe that we have met our burden by that if defense counsel would have investigated this crime, would have looked at all the evidence and put forth the initiative to make a defense strategy, that there would have been a probable outcome in this case. Therefore, Your Honor, I would ask the court to grant the motion. I know that the people have made comments about evidence and lack of evidence showing that that would have happened as far as showing the probability of a different outcome. But that's what the Ginther hearing is for. That's what, you know, the hearing to have, to dive into it is. That's why I would request that we be allowed to have a Ginther hearing. Mr. Smith is potentially looking at a lot of time in prison. And I think justice demands that we provide him with all the opportunity to put forth a defense, which our defense counsel did not allow him to do by not investigating it. And also putting forth the defense of his innocence when defense counsel told him that he being the defendant, that he would be found guilty at trial. So with all of those factors, I believe that that is what we are requesting today, Your Honor, that a Ginther hearing be allowed. Thank you.
Okay. Ms. Blanche, I did have a chance to review your response. I'm happy to hear any highlights from you today.
Just a couple, Your Honor. I think a lot of the allegations that were put in the motion are baseless, and there's not much evidence to support it, just based on Ms. Frazier saying that her client is saying this, but there's no evidence to support his claims. So in order to have a Ginther hearing, she has to show some evidence that there was ineffective assistance of counsel, which she has not done here. In fact, Mr. Bernstein filed 4 motions on behalf of his client. He filed a motion to quash, 2 motions involving excluding photographs, and a motion to exclude witness statements. He spoke to me numerous times on the phone about this case. So to say that he's just completely ineffective and he wasn't working for his client, I think is absolutely ridiculous, honestly, in this case, because he was. He filed probably more motions than most defense attorneys have filed in any other case. So I would ask you, plus everything I wrote in my motion, Your Honor, or my response, I would ask you to deny this motion.
Okay. Matters before the court on defendant's motion for a Ginther hearing. The test for determining whether a criminal defendant has been denied effective assistance of counsel. First, a defendant must show the defense counsel's performance was deficient, and second, the counsel's deficient performance prejudiced the defense. Counsel's performance is measured against an objective standard of reasonableness. To show prejudice, the defendant must show the existence of a reasonable probability that but for counsel's error, the result of the proceeding would have been different. Defendant says the following to support his position of innocence: that Ms. Crystal Lee made inconsistent statements about loss of consciousness. Second, that his relating to his defensive injuries and the fact that the police report stated 2 knives were found, but Ms. Lee stated that she was attacked with 1 knife. Defendant argues that defense's counsel's performance was deficient, and that second, defendant was prejudiced. The court agrees with the people. The defendant has levied baseless allegation after baseless allegation with 0 supporting evidence. Defendant was charged with 1, assault with intent to murder, 2, assault with intent to do great bodily harm, and 3, assault with a dangerous weapon. He pled no contest to counts 1 and 3 with a sentence agreement for 11.5 years to 25 years in MDOC. The court read the preliminary examination transcript, not only in preparation for the motion to quash, but also in reviewing, I think, subsequent motions that there were parts of that attached. Not only did Ms. Lee testify to what happened to her, so did her son, who was an eyewitness. The knife that was used to stab her repeatedly was recovered. The likelihood of a conviction in this matter was high. And let's not forget that the defendant was on parole at the time of the offense and was facing life in prison. So to say that Mr. Bernstein's performance was deficient and prejudicial, as the prosecutor has, as the defense attorney has stated, is simply, there's no basis for that. This defendant was facing potentially life in prison, and Mr. Bernstein negotiated a deal that was significantly less than that. So I don't understand how this was ineffective. We've discussed numerous times the question of the ladle, the question of the 2 knives, but we've also discussed in numerous court occasions, one significant being, well, the preliminary examination, which was not before myself, but the motion to quash, which was before me, where I reviewed that, and there's no question that Mr. Bernstein was effective. So there's no finding at this point. There's no evidentiary basis for the defendant's claim of innocence. Mr. Bernstein was not ineffective, and given the facts and circumstances of the case, I would find that he was actually quite effective. So the motion for the Ginther hearing is denied. We will proceed to sentence in this matter.
The defendant's gone off the screen.
Your Honor, he decided he wanted to go back in his cell. He totally got up and like left.
Okay, so apparently this is a thing. So what I'm going to ask you to do is set up a monitor outside of his cell, and we're going to proceed to sentence him. I'll give you about 10 minutes if we could do that. We've done that in the last couple of weeks, so should be familiar territory. So we're going to set that monitor up and we're going to proceed to sentence, okay?
He's actually out on his out time and then Mr. Smith, come on out.
I mean, hell, I don't care if we adjourn it. I mean,
Honestly, at this point, I told defense counsel this because I knew this was gonna happen. He is failing to appear for sentencing, which at this point, he has to understand that I can withdraw my sentencing agreement with him. And we can move to sentencing and judge at that point, you don't have to abide by the 11 and a half sentencing agreement years. And I've already told the defense attorney to let him know that he's supposed to be here for sentencing. The victim's here today. She wants to make an impact statement. And for defendants just to get up and walk out of the courtroom or walk off soon and not have to listen to the victim impact statement and not have to be present for sentencing, that's an absolute dishonor to this court, Your Honor. And I'm frankly sick of it. And at this point, if he's not going to abide by sentencing, he's not going to be here today, I'm going to withdraw my sentencing agreement. I'm going to ask you to move to sentence him according to his guidelines.
So he is on his out time right now and he refuses to come to the door, or like he's out in the day area. I don't know. I don't know if you can.
hold that thought. Hold on.
Well, first of all, before we have any discussion on this, okay, we haven't asked him if he's waived his constitutional presence to be here at sentencing.
Yes, if he's walked out, he's walked.
No, in the courtroom. He has a constitutional right to be here in the courtroom.
Right.
And he has not.
Date and time set for sentencing.
Well, let me explain.
Okay.
Okay, he has a right to be in this courtroom. That's my first response to that. Okay, so the court can order him to be here in person. Okay, and before we go.